Your license to practice is safe for the moment. We'll open it up to questions, and we'll start on this side.
Hi, I'm Luann Rohrbach from University of Southern California. This question is for Mark about his study. I'm interested in the relationship between the inclusive policy and the outcomes for the LGBT youth. I wonder if you have some ideas about the mediators of that relationship. You mentioned maybe social norms in general as a mediator, and I wonder if that was operating here particularly with regard to how in Oregon there's quite a diversity of politics in different counties, and then what, in addition to social norms, you think might be a mediator.
Sure, so thanks for your question. I actually think that the peer victimization piece is one of the mediators in this study. So we find that we know that peer victimization is strongly associated with suicide attempts, and it is in this sample. And we know that in counties that had more of these protective policies for LGBT youth, we find a reduction in peer victimization. And so it is serving as a mediator in this sample. One of the problems with using some of these probability-based studies is there's only about, I think there's maybe 90 some odd questions in this, in that sample, in that data set. And so a lot of the mediators we'd like to test, like social norms, there just aren't data to be able to test that. So I think that's why I identified that as an important area for future study, because we just can't look at that particular one in the study. But certainly peer victimization was, and also we looked at depression as well, which served as a partial mediator. So again, in the schools that have these protective policies, we see a reduction in depression, which is also associated with suicide attempts.
Thanks. My name is Thayer Hardwick, and I'm an attorney at the Children's Law Center here in DC. I have a question about how attorneys can work with schools during the first year or so of an anti-bullying policy. In particular, how if there is any research about the best way to encourage implementation and use of the policy as opposed to moving straight to litigation, because that doesn't seem the most effective way, to get compliance and to get buy-in from schools.
First of all, as you know, there were two ways to win a lawsuit. One way is to claim that your client got inadequate procedure. The other way is to do it on the law itself. I think that lawyers have to be proactive as well and make sure the procedures are right, and prepare the school board for what might result in a lawsuit. If most of the state statutes require that school districts, schools document the actions they take, the students that they pull out of class, and so forth. That documentation has really got to be there. Also, and I can't prove this, it's just anecdotal, a lot of these cases are just not tried right. The law itself, as I mentioned quickly, offers an awful lot of discretion. What is material, what is substantial, and all this. But it's also a question of putting on a good factual case. How do you prove as a school district lawyer, for example, that the disruption is material and substantial? Well, it just so happens the courts don't require very much. If bullying some kid, two kids fight one another in a classroom or something, or insult one another in a classroom, that's disruption. Some schools, many schools, have administrators, guidance counselors who spend 50% of their time refereeing student catfights. That's disruption. That ought to win. But I don't think that the school districts put on good enough cases. What about the second part of the Tinker test, the part that talks about the right of students to be let alone? We heard enough yesterday and this morning about what bullying does to kids, that if you ever put an expert witness on the stand and said 1/10 of what we've heard in the last 2 days, that would be enough. And I don't think it's put on. Now, it just so happens that school districts lose an awful lot of these free speech cases. Not the ones involving bullying, but they lose a lot of them. They've lost a lot of them for 30 years. Issues like boys' hair length, can a kid wear a bomber jacket that's got a Confederate flag on it? Can somebody wear a T-shirt that says vote Republican or vote Democratic? Personally, I think school districts ought to lose those cases. There's no reason why a kid can't make a political statement. That's what school is for. But we're going to see more and more bullying cases involving these same standards. And if the lawyer would put on a good case about how much pedagogical time is taken refereeing catfights and how hurtful it is to kids, I think the judges would be receptive. They have to hear it first. It has to be presented to them. I don't think a lot of school districts do the cases properly.
Mark, did you want to comment on sort of the implementation?
Hi, Deborah Temkin from the Robert F. Kennedy Center, and I'll preface this by saying I'm a PhD, I'm not a JD, but I'm wondering, and this is related to the previous question, if you're familiar with the Morrow versus Belaski case that was litigated. I think the decision came the end of last year. The Supreme Court declined to hear the case, which argued that the school had no special relationship with a student and had no obligation to protect them from the abuse of another student. And so I'm wondering how that plays into the legal understanding of a school's obligation in terms of bullying.
Well, that's the case that came out of the Third Circuit, is that right?
Yes.
Yeah. Well, the Third Circuit is something of an outlier in this respect. I mean, there's no purpose in having a test like Tinker or a test like Frazier if the holding of the court is that the school has no relation to the child. And also, as I recall, it's been a while since I read that case involved correct me if I'm wrong, but that case involved a damage action brought by a student. Is that right? That's different than upholding, I think that's different than upholding a disciplinary action taken from the school district. Private damage actions are just different kinds of cases, and as I recall, that one was brought under a statute that required a special relationship in order to recover the money, and that special relationship would exist as a matter of law, I think, under Tinker if it was a school disciplinary case.
Jana?
Jana Juvonen, UCLA. First of all, I think that this bringing the legal perspective into our discussion is just fabulous. I think both of your comments were really, really great, and I think we have to do much more dialogue. Doug, I have a lot of questions, but I'm going to address one question back to Mark, following up the question about mediators. As I recall, there's some study findings that suggest that schools kind of prominent gay-straight alliances. That's where kids feel safer. And I was wondering that in your proposed mediator model, what you actually have is, and I'm curious about your future work in this regard, that could it be that you have school environments where if you have a prominent gay-straight alliance, what that essentially indicates is that there's a recognition of norms that are more tolerant of people who are different from the typical, if you will. That is, there's some recognition of, again, diversity. And that is then leading to why kids are less bullied in that environment.
In this data set, we were able to look at the county level about the prevalence of GSAs in the schools. So the Oregon Healthy Teen Study doesn't release information to investigators on the actual schools that participate in the study, so we can't link it to the actual schools that the youth are in. But other work has certainly suggested that that gay-straight alliances, as you're suggesting, are markers of protective environments for LGBT youth, and has linked that to lower rates of suicide attempts. I'm not aware of if it's been linked particularly to peer victimization or bullying in other studies, but it has been related to protective mental health benefits. In another study, we control for a prevalence of gay-straight alliance, and we still find an effect of the policy over and above that. So it suggests it's a partial mediator, because, but in some ways it's whether or not you think it's a mediator or a confounder, because they're both markers of positive environments. And so is it really the GSA, or is there something about the policy per se? And so we've been able to control for that in other studies showing an association between the policy and the outcome over and above the GSA. So it's suggesting it's a partial mediator, but there is something about having the enumeration of this particular group in the policy that seems to be effective over and above that.
Go ahead.
Hi, my name is Glenn Contav. I'm part of the youth panel, and I'm also a student at Professor Abrams' alma mater, Wesleyan University. Go West.
Go red and black.
And yeah, so my question is actually directed at you, Professor
Okay.
Abrams. So it's in the broader context of assault. You said there's no legal protection for students as far as assault goes.
Yeah.
And I was just curious if there were any concrete legal methods to bypass the precedents that fail to protect victimized students.
Well, again, it depends. It's a good question. It's what I would expect from somebody from Wesleyan. It depends upon how the case is argued. Understand that what kind of discipline is meted out to student bullies? They don't get life in prison. They might get suspended for a couple of days. They might have to change schools. If they go to juvenile or family court, there could be a modest sanction for some period of time. If a school would focus on the assault or the threat, they wouldn't have to get into this constitutional thicket about First Amendment speech and all this stuff, because you can, and for those of you who are not lawyers in the audience, which mercifully is most of you, when I say assault, pushing, shoving, spitting, throwing a pencil at somebody, all of those things are assaults. You can discipline that, and the student's not going to get beyond first base with a First Amendment speech claim. You don't have to discipline the speech to mete out the kind of sanction that you would mete out by focusing on the assault or the unprotected threat. But again, a lot of lawyers are conditioned to going for the jugular. You know that. That's the thing up here. Go for the jugular and dive headlong into the First Amendment. And the school district doesn't have to, in most cases, doesn't have to go there, because most bullying involves assaults of one form or another. Face-to-face bullying, it's sort of what it is. And cyberbullying, I mean, to think about the celebrated suicide cases that made the headlines in the last couple of years. Every one of those, and first of all, one thing about cyber stuff is that you can remain anonymous a lot of times if you want to, but bullies don't want to. They crave an audience. And many of them also commit physical assaults once they finish their cyberbullying, and everybody knows who they are. In these suicide cases, everybody in the school knew who the perpetrators were. They didn't try to keep it a secret, and it wasn't a secret. So I think there's got to be some innovation in how these cases are brought and how they're defended and how they're argued.
So I have a couple of follow-up questions. First, Doug, I wonder if you could speak about what risk there might be in thinking about these or pursuing these cases as assault cases. We heard in the peer intervention panel that the negative effects of grouping deviant people together, and does treating this as assault and something more serious, risk heading in that direction? And the second question is for both of you. The law is frequently used, when we're addressing social harm, the law is frequently used to, first and foremost, as a stick, to punish the deviant behavior. And we forget about the other half of the law, which is to incentivize positive outcomes. So I wonder if you could speak to that and where you see the law perhaps playing a role in incentivizing better responses and not simply punishing bad behavior.
Well, taking the first part of the question first, not being a behavioral scientist and only having some experience with local, it's a big country out there, having experience with the local school districts out where I live in Missouri, the prevalence of bullying is so great. I mean, the numbers are so daunting that my sense is that school districts normally don't move against an incident of bullying and impose formal discipline unless it really, really is serious. And at that point, it becomes so serious that maybe calling something assault rather than in violation of free speech doesn't matter anymore very much. I don't really know. I'd have to leave that to the behavioral scientists. One thing I would mention to those of you, to anyone who is a school administrator or a teacher, is that the reason why parents tend to bring these lawsuits, they'll file $1 million lawsuit in federal court claiming you violated my little bully's kind of First Amendment rights. They don't expect to see a dime, and they're not going to see a dime. They want a settlement, and 90% of civil cases in this country are settled anyway. And the settlement is they want the disciplinary sanction expunged from the record. And that's when the school might back down and just do it. You might gently remind the parents how short-sighted that they are in the days of the internet. If they file a lawsuit, that lawsuit is on the internet and the public files like forever. If you file a lawsuit, any name search, little Johnny Jones is disciplined for bullying, and his parents file $1 million lawsuit. Well, you do a name search for Johnny Jones for the rest of his life, you're going to find out that he was a bully when he was in high school. And if he happens to get into the newspaper's going to be on the internet forever. It's going to be checked by employers. It's going to be checked for any time they want to go to graduate school or a commission or a committee or something like that. I won't be around here 50 years from now, but I'd like to see a Supreme Court confirmation where the candidate is a documented bully because of something he did when he was 16 years old. It's still on the internet. These parents might be smart to take the 2-day suspension and not make heroes or martyrs out of their own children in the age of the internet.
I guess to answer the part about incentivizing, I don't know if this is my more hopeful or positivist view, but I think that there's certainly precedence in public health for having social policies incentivize positive behaviors. I'm thinking about seatbelt laws, for instance. And I think that there are aspects of anti-bullying policies that we currently have that actually are incentivizing better behaviors. So I think, for instance, some of the aspects of the policies around enumerating specific groups I see as important around creating and fostering more diverse environments. So I see that less as punitive and more as inculcating a more positive and diverse environment in the school setting. I think things like training and prevention of teachers is also much more in that mindset of creating a more positive and inclusive environment for youth. Then of course, there are also aspects of the policies that are more punitive, so things around sanctions or legal remedies. And I think, in some ways, we've put the cart before the proverbial horse here in I don't think we have a good understanding yet of which of those is more important in these policies with respect to reducing bullying and related behaviors. If you take a behavioral sciences approach, some of the positive reinforcement might be a more effective approach around some of these aggressive behaviors. But I think that's an open empirical question, and we need more research that breaks down some of these different components that have been identified to understand which of them in particular are effective in reducing bullying and other related behaviors. I think that's an open and empirical question that we need to examine.
Thank you. I think this is our final question of the morning.
Oh, good. Dorothy Espelage, University of Illinois, and I have a pragmatic kind of question, I think for hopefully if parents are tuning in. I've been involved in a number of lawsuits across the country, all of which we've lost to school districts who hire very expensive psychologists that argue that suicides are actually linked to depression of the child, not the negligence or the lack of due diligence of school districts, so much so that I don't do that work very much anymore because it's a hard battle. So in most of those cases, and you can look at that, I'm not a lawyer, I'm a psychologist, paperwork disappears, documentation disappears. So when I get a call once a week from parents saying my child is being chronically victimized, what do I do? And I was like, document, 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 because there's going to be floods and fires in these schools as soon as there's a lawsuit filed. What else can I tell these parents that, and an example is there's a documentary called Mentor. Many of us are involved in this documentary. This is a school in Ohio where there was 3 suicides linked to negligence around victimization and bullying, and 3 suicides in 1 year, right? And we lost because we had a hired gun that came in and said this child killed herself because of depression, not because she was cyberbullied or harassed or humiliated and went to the nurse's office 300. So my question is, what do I tell these parents beyond keep documentation or move your kid out of that school?
Maybe not very much. Now, I'm familiar with your work, so I'm not in a position to tell you what to tell parents. But I mean, first of all, there's a doctrine in law that's not very well applied. It's applied sometimes, not applied other times. You take your victim as you find them. The quarterback of the football team doesn't get bullied. It should be, and I don't know the social science of it, but it should not be a defense that your child is bullied because she's suffering depression or suffers depression because she's being bullied. Because those are the kind of people, those are the kind of kids who are bullied. It's not a surprise. What do you tell a parent? I've talked to a couple of parents who are in that position. I don't know what you tell them. Do they move the school? Do they, which they may or may not be able to do? Do they seek a formal remedy? Because one of the things that makes bullying so difficult to combat, I think, in the public schools is it's not always clear to the school administrators and teachers what the right remedy is in a particular case. Every case is different. All you have to do is have a formal remedy where a bully is suspended for 5 days or 10 days, and they come back angrier and more vengeful than before because you've imposed a remedy that doesn't quite meet the question. It's a very tough issue, and I guess you would listen to the parent and decide among some bad alternatives. How do you make the child's life less worse than what's going on? I was very impressed yesterday with the discussion about bullied kids finding one friend. That may be part of the answer. I've heard some circumstances where that really works. But you're dealing in a case like that with a bunch of alternatives, none of which is 100% really good.
Yes.
I'm just going to say one thing really quickly. I know we're wrapping up. This might be one area where the state of the legal practices and laws around LGBT might be an interesting case point for some of these other court cases. And this is a dissertation in the making. I do not know the answer to this, but it's been interesting to me to see in some of the court cases I've been involved in, unrelated to bullying, how open the judges in the cases have been around the use of social science data to really move laws and policies in this arena. And the one bullying case I've worked in, again, related to sexual orientation, bringing the published data, they pulled the case and decided outside of court because the school district was so concerned that the data showed how bullying can really affect LGBT youth. It's not as if the research isn't there in the other area, of course, and so I'm not sure why social science work is really being utilized in this one domain and not in the others. But I think this is where partnerships with social scientists and legal scholars can be helpful in trying to move this forward and understand the ways in which we can use social science data to push at some of these legal levers in a more promising way.
Yeah, the question that was raised before about the Third Circuit case was a very good one because it distinguishes between statutes that command the school district, you must do such and such. And these can be state statutes, any of the 49, but there are also federal civil rights statutes that might apply when the target happens to be targeted because of religion or race or ethnicity or sexual orientation and so forth. That's one type of case where the statute says to the school district, you must do something. The second kind of case is, can an injured plaintiff recover private damages if the school district doesn't do anything? And the documentation, you can document all you want. If the school district is reluctant to face a lawsuit, it's up to the public authorities to sue the school district for noncompliance, which they may not do. You may not have a private remedy. You normally don't have a private remedy because of the special relationship issue that was talked about in the question.
Thank you both. I have one small announcement and one request. So we are about, in 30 seconds, we'll break for lunch. We'll reconvene and start at 1 o'clock. As a reminder, the cafeteria is downstairs. The committee will meet in the same place as yesterday. And the small request is please join me in thanking our panelists for their contributions.